After reviewing the arguments presented before this court, this is my ruling.
In the closing years of the 19th century, Britain found itself in the grip of successive waves of influenza. Anxiety traveled faster than the illness itself. Public fear was palpable, and the marketplace responded with urgency. Supposed cures multiplied. Among them stood a striking advertisement, confident, precise, and unapologetically bold. It did not speak in vague assurances. It set out clear instructions. It promised a defined reward.
£100 reward will be paid by the Carbolic smoke ball company to any person who contracts influenza after having used the ball 3 times daily for 2 weeks. Gentlemen, the smoke ball.
To underscore its seriousness, it declared that money had been deposited in a bank as evidence of its good faith.
£1,000 is now deposited with the Alliance Bank, showing our sincerity.
But behind the confident words printed in newspapers across England, the reality inside the company's offices was far less honorable. The promise of £100 was never meant to be taken seriously. To the directors, it was merely a clever marketing device, a dramatic claim designed to sell more smoke balls, not a reward they ever truly intended to pay. Soon the test of that promise would arrive. Despite following the instructions exactly, Mrs. Carlill contracted influenza. And when she sought the £100 that had been publicly promised, the company refused to pay.
I followed the instructions to the letter.
We'll sue them for this, don't worry.
Believing the company's public promise to be genuine, she wrote a formal letter to the Carbolic Smokeball Company, informing them that she had complied with the advertisement and was therefore entitled to the £100 reward. When the letter arrived at the company's office, it was read with little concern. Rather than preparing payment, the directors dismissed the claim outright. To them, the advertisement had never been intended as a binding promise. Seeking reassurance, they consulted their legal practitioner, who advised them that they could rely on a defense familiar in commercial practice, that the advertisement was merely a sales puff, an exaggerated statement made to promote a product, and not a serious offer intended to create a legally binding contract. Confident in this position, the company refused to pay Mrs. Carlill the promised £100. Faced with the company's refusal, Mrs. Carlill was not prepared to abandon her claim. The advertisement had been clear, the conditions had been followed, and the promise of £100 had been publicly declared. Determined to enforce what she believed was a genuine commitment, she engaged the services of a legal practitioner. After carefully examining the advertisement and the surrounding circumstances, her lawyer concluded that the matter could be framed as a breach of contract. The argument was simple but powerful. The company had made a clear offer to the public. Mrs. Carlill had accepted that offer by performing the required conditions, and the promised reward had not been paid. With that reasoning, legal proceedings were commenced against the Carbolic Smokeball Company, bringing the dispute before the courts in the now famous case of Carlill versus Carbolic Smokeball Company.
What began as a simple claim for a promised reward soon evolved into a fierce legal contest over the very foundations of contract law. The dispute first appeared before the High Court, where the Carbolic Smokeball Company insisted that its advertisement was nothing more than a piece of commercial exaggeration, a mere puff, never intended to create legal obligations. Mrs. Carlill's counsel argued the opposite, that the company had made a clear and definite offer to the public, and that Mrs. Carlill had accepted it by performing the conditions exactly as stated. The stakes quickly grew larger than the £100 reward itself. At issue was whether a public advertisement could amount to a binding offer in law. The battle did not end in the High Court. The company carried the fight further, appealing the decision and bringing the matter before the Court of Appeal. There, distinguished judges, including Nathaniel Lindley, prepared to consider the arguments that had captured public attention.
My lords, this advertisement was not an offer. It was an invitation to treat. Explain further. What do you mean by invitation to treat? My lord, it is a preliminary communication. My lords, a communication inviting negotiation, not a binding promise, as is in this case. My lords, the advertisement contains certainty of terms. It specifies the following: the reward, the conditions, the duration, the deposit of £1,000 as evidence of seriousness. And what about acceptance? My lords, acceptance occurred through performance. She performed the conditions required. My lords, there was no notification of acceptance. In unilateral contracts, performance constitutes acceptance. My lords, the advertisement is too vague to constitute a contract. It does not specify time for performance. My lords, it specifies 3 times daily for 2 weeks. My lords, it does not state to whom notification must be given. My lords, in unilateral contracts, notification is not required before performance. It exposes the company to unlimited liability. That is the consequence of careless drafting. Where is the consideration flowing from Mrs. Carlill? She used the smoke ball, increasing sales and reputation. That is sufficient consideration. You deposited £1,000 in a bank. That suggests seriousness, not jest. There was no intention to be legally bound. Consideration need not benefit the promiser directly. It must simply represent value in the eyes of the law. My lords, the facts are clear. The evidence proves my client's right. We ask for judgment in our favor.
Distinguished judges, including Nathaniel Lindley, prepared to consider the arguments that had captured public attention. At last, the day of judgment arrived in the landmark case of Carlill versus Carbolic Smoke Ball Company.
After reviewing the arguments presented before this court, this is my ruling. The advertisement was an offer to the world at large. Mrs. Carlill accepted by performing the conditions. In my judgment, the advertisement issued by the Carbolic Smoke Ball Company was not a mere puff or idle statement, but a definite offer made to the world at large. The language of the advertisement was clear and certain, promising a reward of £100 to any person who, having used the smoke ball according to the prescribed instructions, nevertheless contracted influenza. The deposit of £1,000 in the bank was strong evidence of the company's sincerity and intention to be legally bound. Mrs. Carl, having performed the conditions stipulated in the advertisement, thereby accepted the offer by conduct, and sufficient consideration moved from her in the inconvenience and use of the smoke ball. Accordingly, a binding contract arose, and the plaintiff is entitled to recover the promised reward.
As the court pleases.
This is the judgment of the court. Thank you all, and have a great day.
What emerged from this sequence of events was not merely a dispute about a failed remedy, but a defining exposition of contractual principle. The case illuminated the nature of a unilateral contract, a binding promise made in exchange for the performance of a specified act. In such arrangements, acceptance does not arise from prior notification or reciprocal dialogue. It crystallizes upon completion of the act itself. The court articulated enduring doctrines that continue to shape commercial dealings. An advertisement may amount to a legally enforceable offer where its terms are sufficiently certain and evince clear intention. Acceptance can be effected through performance alone. The act of depositing money may evidence a serious intention to create legal relations. From a simple rubber smoke ball emerged doctrinal clarity. The judiciary drew a decisive boundary. Commercial hyperbole has limits, and where certainty and intention converge, the law will intervene. A promise addressed to the world at large can, in the right circumstances, bind the one who makes it.